Good evening, everyone. We'll begin with the session in the next 5 minutes. Good evening, everyone. I hope I'm audible to all of you. All right, thank you for the confirmation. evening, everyone. A very warm welcome to all of you present here today. I hope you are doing well and excited for yet another informative session organized by the Legal Quorum. Thank you for joining us this evening despite your weekend schedules. It truly means a lot. So, before we begin, let me quickly introduce myself. I'm Harshi Gautam and I'll be your host for today's session. We are thrilled to have you with us for this free legal webinar on a topic that forms the very foundation of civil procedure law, that is, understanding Order 9 of CPC, procedural mandates and legal consequences. A little introduction to the Legal Quorum. At the Legal Quorum, we aim to make the law accessible, engaging, and empowering for everyone, from students and legal professionals to those simply curious about how the legal system works. We share high quality content, conduct informative sessions like this, and constantly strive to build a community of learners, thinkers, and change makers. Now, moving to the highlight of today's webinar, our esteemed speaker, we are honored to host Dr. Kumari Ranjana Bharti, who currently serves as an assistant professor at the School of Law Christ, deemed to be University, Delhi NCR. With over 11 years of combined experience in legal practice and academia, Dr. Bharti brings both courtroom insight and classroom depth to our platform today. She is an alumna of ILS Law College Pune and has served as the State Junior Counsel to the Government of Bihar while practicing at the Honorable Patna High Court. Her legal experience extends to district and sessions courts and various tribunals in Greater Noida, including LARR Court, MACT Tribunal, and the Consumer Forum. Dr. Bharti has also been a faculty member at the School of Law, Belgodia's University, and currently plays a key role in academic development at Christ University, Delhi NCR. Thank you so much, ma'am, for joining us today and taking out your valuable time to enlighten us on such an important and practical topic. Without taking any more time, I now invite Dr. Kumari Ranjana Bharti to take this session forward and share her insights on Order 9 of the Civil Procedure Code and its procedural significance. Over to you, ma'am.
Thank you, Harshi. Thank you so much. That was wonderful introduction. Good evening, everyone. I hope everyone is doing good. All right. So today, let me first share my screen with all of you. One second. Is it visible? Is the screen visible? All right. Thank you for your response. All
Yes,
right.
ma'am, your screen is visible. Yes,
Thank
ma'am.
thank you for your response. So today we are going to deal with civil procedure law, a very tiny part of civil procedure law. When we talk about civil procedure law, it is a vast law, and this is basically that one particular law that governs the proceedings of the civil case, how the civil case travels, and how the civil cases are to be, procedures that needs to be followed while a civil case is being filed, right? It deals with all the matter concerning to jurisprudence, and then the pleadings, how the pleadings should be, how the plaint should be, how and what should be the written statement. It also deals with the evidences that needs to be laid and how to be laid, and then how you can go ahead in appeal in case you're not satisfied with the decision of the court, right? So you see, this particular code is from the year 1908. Okay, it's a very, very, very old law, but still makes so much of relevance and makes so much of sense in today's contemporary time, right? So while we talk about a civil procedure code, there are 158 sections altogether in it, and there's one schedule. Within that one schedule, there are 51 orders. All right. And within those orders, every order will have certain rules to it. Now, people often feel that it's a very complex thing just because orders and rules are involved. How many of you think it's a little complex just because of the order and the rules that are involved? Can I have a quick response? How many of you think it's little complex? Yes, Dave?
Yes, ma'am, it's complex.
Yes. So what I want to talk
I
about,
haven't studied yet.
Okay, so people who've studied it feel it's little complex just because of there's sections, there's rules, there's order. All right. So I would just ask you all not to be afraid of the terminologies. It's nothing. The sections are there, and then you have the order, and within each order there'll be specific rules laid down. Rules are number one, what you have to do; number two, what you have to do; and number three, and so on and so forth. So every order might have various number of rules. Some may have 5 rules, some may have 10, 15, 20, depending on the order. You'll have number of rules laid down to it, right? So today, specifically what we are dealing is order 9. Now, what does order 9 talk about? So whenever a case is filed, so I'll come to that. So order 9 basically deals with the appearances of the party and the consequences of the non-appearance. So say for example, if you have filed a case, or maybe a case has been filed against you, and you need to appear before the court, but you don't appear. So now you will have to bear some consequences. If you are the petitioner, you have filed the case and you yourself is not appearing. Or maybe the summons have been served to you, you are aware that the case has been filed against you, but you do not appear before the court. Now, what would be the consequences? So, when we talk about Order 9 specifically deals with the appearances of party and what would be the possible consequences if they do not appear, right? So, before I take you there, a little gist about how the civil case travel, right? So, first of all, what happened? A civil suit or a case is filed, right? Then what happens? Summon will be served by whom? By the petitioner. Plaintiff who has actually filed the case, he will, sort of file the case, and then it is his responsibility to send a summon to the defendant in order to make him aware that a case has been filed against him. Unless he is aware, how would he come and appear before the court and put forth his points, right? So the one who is filing the case is the one who will be responsible to sending a note, sending a summon to the opposite party to make him aware of the fact that a case has been instituted against him. Now, once the case has been instituted, once the defendant is aware of the fact that the case has been instituted against him, what will he do? He has got two options. He would either appear before the court or he will not appear. If at all he appears, can you see my cursor as well? If he appears, he will do two things. What? Either he will file a written statement or he will not file a written statement. Now, if he's not appearing, right, we'll get into on either if he appears before the court, he will either file the written statement or he will not file the written statement, right? And then if at all he files the written statement, what will happen? The issues will be framed of the case, and then evidences will be laid, and the evidences of the plaintiff will be recorded, and the evidences of the defendant will be recorded, and then the final arguments will be happening, and then the judgment will be coming, right? But if he does not appear, only the evidences of the plaintiff will be recorded, and an ex parte order will be passed against the defendant, right? And then the argument of only the plaintiff will be heard, and then judgment shall be there, right? Now, so so you saw that, how a civil case travels, right? Once the case has been instituted, the plaintiff will intimate the defendant. He will send the summons, and then we saw the procedure that is going to take place step by step, right? Now we are on to the rules. Now, what are the various rules that is laid down under Order 9? There are various rules that is laid down. So, when we talk specifically about Order 9, there are 14 rules laid down, right? 14 rules to Order 9, right? So, now we'll see each and every rule one by one, what the rule is saying. We will try to understand. We are again, I'm repeating, we are onto the facts that appearances of the party and the consequences of their non-appearance. Now, the first rule says parties to appear on date fixed in summons for defendant to appear and answer, right? So, what happens once a case has been instituted by the plaintiff? The summons are served to the defendants. The defendants are made aware that case has been filed against you. Now, what will the content of the summons be? The content shall have the mention as to the nature of the case, when he is to appear, where he is to appear, the court number will be written, the date will be written, and the time of his appearance in the court shall be written, right? So whenever there is a date mentioned, whenever the summons is being served, the parties have to appear on that particular date. Now, it is not only onto the defendant to appear, it is for the plaintiff also to appear. Both the parties will be appearing on the date on which the summons says that they need to appear. The date and the time mentioned in the summon, on that particular date, the both the parties shall appear before the court and answer the court, right? Now, after that, we come to rule 2. Now, what does rule 2 talk about? Rule 2 talk about the dismissal of the suit when summons not served in consequence of plaintiff's failure to pay cost. Now, the first reading of this section might look a little complex, so I've just tried to make this cartoon animated, pictures, so as to make you easy, to help you understand it in a very easy and a lighter manner. Because yes, I've been teaching civil procedure laws, and students have been saying that it is a complex law for them to understand, but then I've just tried to make it a little more easier for you. So what happens? The suit shall dismiss. When the suit shall dismiss, if the plaintiff have failed to serve the summons. Now, the first thing that the plaintiff need to do once they file a suit is to serve a summon to the defendant in order to make them aware that this is the issue, and you need to appear before the court and answer. But then, if the plaintiff have failed, then what will happen? The court shall straight away dismiss the suit. Does that sound justifiable? Does that sound justifiable? So what happened? It is not, because if the plaintiff have failed to reach the court, it might be for various reasons, right? There can be various reasons because of which the plaintiff is unable to appear, fails to file the summons, right? So now, if the plaintiff come before the court and tell the court that there was sufficient cause as to why they were not able to file the suit, file the they were not able to serve the summons, right? So now, if that is happening, if the summons have not been served by the plaintiff, if the court fees that they submitted was insufficient, or if they failed to give another copy. So whenever you're filing a case in the a petition in the court, you need to give a court's copy. The defendant will have its own copy. The one copy is required to be given to the defendant. Unless a copy is given to them, unless they are aware of the case that is being instituted against them, how are they supposed to prepare the written statement? How are they supposed to know what nature of case has been filed, what are the allegations, and how they can defend themselves, right? So if these three happens, if the petitioner or the plaintiff has failed to serve the summons to the defendant, or if the court fee that they submitted was very less, or if they failed to give a copy of the plaint to the defendant, then in that particular case, the court shall dismiss the suit straight away. However, under one condition, this dismissal can be stopped. Now, what is that condition? That if the defendant themselves appear before the court and tell the court that Your Lordship, I'm aware of the fact and I have appeared before you. Now, how are they supposed to know? So you have to understand, whenever there's a conflict happening, whenever there's an issue arising between two parties, they are well aware that this is a burning issue, and then both of them somewhere know that he's right and he's wrong, and this person will be filing a case, right? So once they are aware, and then also we live in a very small world wherein everybody is connected. So via they are aware of the fact that a case has been instituted. So even if the plaintiff has failed to send the summons, even if the plaintiff have failed to file the court fees, or even if the plaintiff have failed to serve another copy, the defendant still can appear. If they have the knowledge, they can still appear before the court and say, Your Lordship, I'm aware of the fact and hence I'm here. In that case, if the defendant appears, irrespective of the failures of the plaintiff, the case will not be dismissed. However, if these three things are happening and there's a failure on the part of the defendant, plaintiff, then the case shall be dismissed. Now, we are on to rule 3. So anybody having question, I would request that I'll the flow will be broken. So I'll take all your questions at the end of the session. So kindly allow me to go ahead with it. Okay. All right. So rule 3. Now, what does rule 3 says? When neither party appears to the suit shall be dismissed. So what happens? The judge is there, right? The item number has been called out for hearing, but then neither the plaintiff who filed the suit has appeared, nor the defendant has appeared. Now, what is the judge supposed to do? So in that particular case, the judge shall dismiss the suit. Why so? Because if we talk about India, every time you're having a complex where the second thing that comes, I'll see you in the court, right? And then they'll go and they'll file a case in the court, right? But after that, the matter has been sorted out. They're like, no, yeah, we were, forever friends. Then why are we fighting? Let's not proceed the suit. In that particular case, how is the judge supposed to know? So if the parties are not coming, not on the first very day, the court will dismiss the case as it is. The court shall wait or maybe give another date to the case. Even irrespective of the fact that neither the party has appeared, it is upon the discretion of the court. The court will give yet another opportunity. The court will give yet another date to that particular case. If the parties appear, that's well and good. If the parties are not able to appear, then in that case, the court shall, on the subsequent dates, dismiss the suit completely. Right? Now, we are on to rule 4 of order 9. Now, what does rule 4 tells us? The rule 4 tells us plaintiff may bring fresh suit or court may restore suit to file. So now what's happening? We've seen that if the plaintiff has instituted a case and the plaintiff himself is not appearing, what will happen? The case shall be dismissed, right? The other one was where neither the party is appearing. Or rule 2 says dismissal if there's failure for the plaintiff to carry out all these particulars that I've already explained. So in the loop of rule 2 and 3, if there's a failure to comply with rule 2 and 3, then rule 4 says that the plaintiff may, and if there's a dismissal of the suit, then the court gives a little provision to the plaintiff to file a fresh suit. Now, they have failed to appear. Now, the plaintiff have failed to serve the summons. The plaintiff has not deposited the appropriate court fees. The plaintiff has not given the copy to the, copy of the petition to the defendant. There has been so much of lacunas. The court can dismiss it, right? The court has dismissed, say, for example, or if the court has dismissed the suit because neither the party were appearing. So rule 2 and rule 3. As per both of these rules, if the court has dismissed the suit, does it mean that the plaintiff should not get another chance? Does it mean the plaintiff should not get another chance? Can contingencies happen with anyone? Yes. So the contingency can happen with anyone. So maybe because of some reason he has failed to comply with the procedures laid down, but then he should be given a chance. Now, when does he get this chance? So the plaintiff will bring a fresh suit when on the dismissal of the suit. If the case is dismissed by the court, the plaintiff will still bring a fresh suit to the court, right? and they will ask for a dismissal of the order, to set aside the dismissal order. The plaintiff will say, your lordship, I have valid reason why I could not, come on the date fixed, or the time when the item number was called for hearing. I have sufficient and genuine reasons why I could not come in that particular, and by the virtue of that, lordship, I urge you or request you to kindly set aside the dismissal order. Do not dismiss my case. I would request for a fresh suit. The court, if the court, it is on the discretion again, on the court. If the court feels there was sufficient cause, there was sufficient cause. Say, for example, the plaintiff, after filing the suit on the date of the fixed hearing, he met with an accident, maybe, or maybe some natural calamity happened, the flood happened, or earthquake happened, he could not reach the court premises, right? In that particular case, what will happen if the court is satisfied with the fact that there was a sufficient reason why this particular person could not reach the court? In that particular situation, the court may either with cost or without cost, the court will restore or let set aside the dismissal order and allow a fresh suit to be filed by the petitioner, right? So that is what Rule 4 tells us. Now we are on to Rule 5. What does Rule 5 tells us, right? Let's see what Rule 5 has to tell us. Rule 5 says dismissal of suit where plaintiff, after summons return unserved, fails for fresh summons. Now what happens once a plaintiff is filing the summons, is sending the summons to the defendant? Now, the plaintiff can very easily say, Your Lordship, or he does not want the other party to appear and put forth his side, and he says, Look, Your Lordship, he's not appearing. Please pass an order in my favor, pass an ex parte decree, and pass an order in my favor. He can do so. People are of that mindset. So, what happens? The court will not take or entertain the fact that you had sent the summons and the summons have not been served. If at all the plaintiffs have sent the summon and it returns unserved, it is not served. The defendant does not get the plaintiff. Now, how are we to evaluate whether the defendant have received they have received the summons or they have not received? What is the proof? So the proof is the postal ticket. All right. So when we are doing making a speed post, you get a receipt, right? That receipt will tell whether the item is delivered or not delivered. That receipt will be placed on a piece of paper, like when we practice in the district court, we place it on the white sheet and then we submit it along with the tracking report. When it was dispatched, when it reached, and when what happened, and then a tracking report will be there. So along with the receipt and the tracking report, it shall be submitted. Now, once it is submitted, the court very clearly knows that whether the summons have been served or the summons have been not served. So in case the summons have not been served, it is the duty of the plaintiff to resend the summons again, right? And what is the time period? It is only within 7 days. The plaintiff need to resend the summons, right? So if he fails to resend the summons, right, then the court will dismiss it. The court will dismiss the suit. Why? Because you did not inform the other party. You're wasting the court's time. The other party is not appearing. So in that, by the virtue of that, the court will be dismissing the suit. However, the court will not dismiss the suit if the plaintiff proves the reason why the summons are coming unserved, returning unserved. And what could be the potential reason? The potential reason is that despite the plaintiff's endeavors to find the residence of the defendant, he's unable to find the residence. Can you see the picture? My cursor is there. Can you see it? Please respond. All right. So he tried his level best to find out the address or the residence of the defendant, but he could not find it. Then he goes on to say, tell the coach that, Your Lordship, even there has been several instances where the postman has tried to serve the notice to the defendant, but the defendant has been hiding, he's absconding, he's not at his residence, he's not receiving the summons. Then the coach feels okay, that is justifiable. And if at all the summons was served, but then the summons was served very late. Now, if the plaintiff assigns a good reason as to why there was delay in serving the summon so late to the defendant, then in that case, again, the court shall, understand that there was a sufficient reason. Maybe natural calamity happened. Maybe the advocate was not well. Maybe there was some other XYZ reason why it took a little bit more time to send the summons and then to receive the summon, and then for the and the reason why there was default in sending the summon. If the court is satisfied with all these three reasons, then what will happen? The court will allow a fresh suit. Okay, the court will allow the plaintiff to file another fresh suit. Clear? I hope rule 5 is clear to everybody. Repeating, we are on to order number 9, which deals with the appearances and consequences of the non-appearance of the parties. Right? Now let's move ahead. Let's go on to rule number 6. Now, what does rule number 6 tells us? Rule number 6 tells us procedure when only plaintiff appears, right? Only the plaintiff is appearing and the defendant is not appearing. Then what happens in that particular case if we tell the court that the summons have been duly served, still the defendants are not appearing? In that particular case, what the court will do, the court will go ahead and dismiss the court will go ahead and pass an ex parte order. Okay, it will pass an order in favor of the plaintiff and without hearing the part of the defendant, because he did not appear to put forth his part, right? So the court will go ahead. If the defendant is not appearing, the plaintiff is appearing, and the plaintiff tells the court that the summons have been duly served, the court shall pass an ex parte decree in favor of the plaintiff, right? And then what happens if it appears to the court that the summons have not been duly served? Then what happens? The court will ask for another second summons to be served to the defendants, right? Now, what happens if it comes to the knowledge of the court that the summons were served, right? It were served, but then it was not served within sufficient time, right? So you have to understand the geography of India. We are a huge country when we talk about the land masses, right? The terrains, right? So we're a big nation. We're a big country. So what happens? A person staying in Chennai and a case has been instituted against him in Assam. So he needs some considerable time to travel from Chennai to Assam, right? Right? So in that particular case, so say for example, the date of hearing is tomorrow, and today somebody gets this summon that I need to appear in Assam court today, and I'm in Chennai. How am I supposed to do it? Right? I did receive the summons. Did I receive the summons? Yes. But was it within sufficient time? The answer is no. There was no sufficient time for me to reach the Assam court, right? In that particular case, if the court is satisfied that this is the reason why the plaintiff is not appearing, the defendant this can be one potential reason why the defendant would not appear within time, right? Now, if that happens, the petitioner shall be imposed with some cost, right? The petitioner will be imposed with some cost, right? Now we move on to rule 7. What does rule 7 tells us? Procedure when defendant appears. The defendant is appearing on the date of adjourned hearing and assigns good cause for his non-appearance, right? Previous non-appearance. So what happens? The defendant on the date of adjourn, he appears and he tells the court that there was sufficient reason as to why he could not appear before the court. as to why he could not appear before the court, and he assigns a very good reason, then and there's sufficient cause, maybe natural calamity, that we've already discussed. There could be potential different reasons why he could not appear before the court. Now, if the court is satisfied that all right, there it looks like you had sufficient cause as to why you could not appear before the court, then the court either allow the defendants with cost or without cost, right? Now, what happens now? The procedure when defendant appears on the date of adjourn hearing assigns good cause for his non-appearance on the previous dates. Now, once he says that he has appeared, so now he comes and tells the court that I'm appearing, but then what happened? The opposite party, the plaintiff, is not appearing, right? No, sorry, I'm sorry. So what happens? The defendant comes and he appears before the court and he assigns good cause as to why he was not able to appear previously. Then in that case, the court will impose or may not. If the court is convinced that he really had very strong reason for failure of his appearance before the court on the previous hearing, then the court shall start a fresh suit. Shall start considering him to to have been appearing on the date that he has appeared. Now, on this particular date, if the court wants, the court will impose cost on this particular defendant who has appeared. Or if the court is very satisfied, the court might not impose any cost because he came late, right? And then now that he has appeared, the court shall take into consideration this date for his first appearance. Okay. Now let's go on to rule number 7. Procedure when defendant only appears. So what happens on the date of the fixed hearing, the date and time of the fixed hearing, it is only the defendant that is present and he's only appearing. Then and the plaintiff who has filed the suit is not appearing. Then what will happen? The court will go ahead and dismiss the case. Why so? It's because now it's an exploitation. The opposite party just, they had a fight, and then the plaintiff said, now I'll teach you a lesson. I'll drag you to the court. He goes, he files a case, and then he's off. He doesn't have to do anything. So it is a harassment to the defendant. You do not know whether the defendant is guilty or not guilty. But he's being harassed. He has to come because the summons have been served to him. He has to come because if he does not appear and put forth his side, contrary action might be taken against him, right? So it's an exploitation. So in that particular case, if only the defendant is appearing and the plaintiff is not appearing, in that particular case, the case shall be dismissed. There will be no case. The case shall be dismissed, right? But then, if on his presence, if he appears and if he tells the court, all right, your lordship, even though the plaintiff have not appeared, the defendants have appeared, defendant comes ahead and said, all right, your lordship, this case has been filed against me, I'm aware of it, this was the issue, and I'm liable for only this part. If there was 10 rupees involved in the case, and if the defendant was liable for only 5 rupees, he'll come to the court for put a deposit of 5 rupees, and then he'll say that I'm not responsible for another 5 rupees, and then in that case a decree will be passed in his favor, and the court shall then proceed, right? Now we come to rule 9, decree against plaintiff by default, fresh suit. So we saw in rule 8 that only the defendant appeared, the plaintiff who filed the suit did not appear. Now what happens? Should we give him a benefit of doubt? Should we allow him, give him another chance? Should we give him another chance? If contingencies can happen with the defendant and they fails to appear, contingencies can happen with the plaintiff as well, right? So should we give another chance to the plaintiff to come ahead and put forth his side? right? So what happened? So what happens if the suit has been dismissed, right? The plaintiff will come to the court and ask for the setting aside of the dismissal order. He'll file an application and ask the court, Your Lordship, kindly set aside the dismissal order, Your Lordship. Why? Why should I do that? Because, Your Lordship, I have sufficient reason, I have sufficient cause for my non-appearance. And if the court is satisfied again, then on basis of that, the court shall set aside the order, right? Set aside the dismissal order. Now, once the court is setting aside the dismissal order, now the court has already passed a favorable order in favor of the defendant, right? And now the defendant is very happy. I've got the order in my favor. Now the plaintiff comes in and he asks for dismissal. And the defendant is sitting home. He's not aware because he thinks that the order has been passed in my favor. Now, can the court go ahead and set aside the order? The answer is no. The court cannot do that. Before the court do so, the court will have to tell the defendants. The court will have to send a notice to the defendant, telling the defendant that this is the thing and this is the case. Now the plaintiff have appeared, and the court is the order that has been passed in your favor will be stayed unless the defendant, the plaintiff who has appeared now, is being heard. And then after hearing both the parties, the court shall come to a final judgment, right? Now, we shall come to rule 10. Now, we are on to the consequences. We see when the parties are appearing, not appearing. Now, what would be the repercussions? What will be the consequences of non-appearance of the parties, right? The parties are not appearing. Then what would be the potential consequences of the parties, right? We are on to Rule 10 of Order 9. Rule 10 says procedure in case of non-attendance of one or more several plaintiff. So what happens? There are one or more plaintiff. Can there be a case where there can be more than one plaintiff? Can there be a case where there can be more than one defendant? The answer is yes. So there are cases where we make a lot of other people as parties, right? We make there can be one plaintiff, 10 defendants, 10 plaintiff, one defendant, vice versa, right? So in a case, there can be more than one person involved in a case from either parties, right? So we are on to Rule 10, right? Rule 10 tells us that procedure in consequence of non-appearance of one or more of several parties. So what happens if one or more parties are attending, right? So if there are 10 plaintiffs, right, the other 9 are not appearing, only one is appearing. Now, how would the court proceed? Will the court wait for the other 9 to join in? The answer is no. The court does not have that much of a time, right? So, and you should be aware that if there's one cause of action wherein these parties have come together, and if there's one subject that is involved in the case, all of them are aware, right? However, because of any reason, for any XYZ reason, if 9 of them are not able to appear and only one person is appearing as plaintiff, then the court shall proceed considering that all 9 of them has appeared, right? The court shall proceed as if all the 10 members are present. Even if one person is present and representing, it will be considered that all 9 of them are also appearing and they are there in the case, right? Now, when we talk about Rule 10, Rule 10 and 9 are almost same. Rule 10 and 11 are almost same. The only difference that you see in the definition, if I may come to Rule now 9, it is the plaintiff. Procedure in case of non-appearance of one or more of several plaintiffs. That is Rule 10. Now, when we go on to Rule 11, it says procedure in case of non-attendance of one or more of several defendants. The only difference between both these rules, Rule 10 and 11, is plaintiff and defendant. It is one and the same thing, right? In Rule 11, now the opposite happens. What happens? There are, say, 15 defendants, right? And only one or two defendants are appearing. The rest, say for example, the rest 14, 14 or 13 defendants are not appearing. Now, what is to be done in this particular case? Now, in this particular case, as we were dealing with the plaintiff, we will consider all these defendants to have been appearing before the court. And even if one defendant is present or two defendants is present, the court shall proceed with the proceeding of the case and shall come to a decision, right? Considering that all of these defendants have appeared before the court, right? Now we come on to Rule 13. Now, Rule 13 talks about the consequences of non-attendance without sufficient cause or of order or party order to appear in person. So now what happens? Uh, so there the court has asked the parties to appear, right? The consequences of non-appearance. There is non-appearance. Now, what would be the consequences? And this non-appearance is without sufficient cause. Neither of the party, neither the plaintiff has appeared, nor the defendant has appeared, right? And there is no sufficient cause that is given either by the plaintiff or by the defendant in this particular scenario. What will the court do? Anyone would want to answer that? We are on to Rule 12. Just to ensure that everybody is listening and participating. Law is nothing but common sense. What is law? Law is nothing but common sense. Whatever your common sense says is wrong by law. Whatever your common sense, like prudent common sense, whatever your common sense says is right, is actually right in law, right? So I just want to know your opinion before I explain this to you. Anyone would want to answer this question? What would be the consequences if neither the plaintiff nor the defendants are appearing and they do not give any sufficient cause? Yes,
Ma'am, I think the court is to the case.
the court. Yes, you guys are right. Okay, I see that in answers. Yes, of course. So what happened in the previous rules we saw, the same thing will happen. Subject to the provisions that have been laid down in the foregoing rules, the same shall apply here. Clear? Now we shall move to Rule 13. Now, Rule 13 and 14 is important. Why? Because Rule 13 and 14 talks about the setting aside of an ex parte decree. So, what happens when does a court passes an ex parte decree? When does the court passes an ex parte decree? Yes, anybody?
Ma'am, when the defend or either party not come.
Yes, when the either of the party is not present, or not either of the party, yes. So if the plaintiff has filed the case, right, and the defendant does not appear, now the court is not going to wait for the defendant to come after ensuring that the summons have been served. The summons have been served for the second time. The summons is being delivered. The defendant is aware, but then still he is not appearing. In that particular case, what happened? The court goes ahead and files and passes an ex parte decree in favor of the plaintiff, right? So what happens? The court in this particular scenario, under Rule 13, the court will set aside, once the court has passed this ex parte decree, if it has passed a decree only in the favor of the plaintiff, the defendants are now, at losses, right? So the court passed this decree without hearing the defendant, right? Now, it might so happen that the defendant was not wrong at all. The plaintiff were misleading. And since they did not appear, they could not appear, and they could not put forth their points, the court believed the plaintiff and passed the order in favor of the plaintiff. Now, will the court set aside the order if the defendant appear and say, Your Lordship, there's a major, clinches that has happened. I'm going to suffer a major loss. The answer is yes. Very good. Yes, Yashika. Thank you. So the court will now, what happened? The court will, pass an order to set aside this ex parte decree. The court has passed the favor in passed an order in the favor of plaintiff. Now the that particular order, that particular ex parte order in the favor of the plaintiff shall be set aside. Right? When shall it be set aside? When the defendant appears before the court and they says that there was sufficient cause as to why they were not able to present themselves, and these are the losses that they're going to face if at all they're not heard, right? So that is it. But then the court will set aside the order, right? But then there are certain cases or there are certain instances which is provided under this particular rule, which comes within the proviso, the provided area. So the court in two scenarios shall not set aside the order. What are the two scenarios? What are the two scenarios? The first scenario is that if the suit that has been filed is of such a nature that there are 10 defendants in it, right? And if the court goes on to one of the defendants has now appeared and they're asking to set aside the order, but then the nature of the suit is such that if the court goes on to set aside this ex parte order, then against one defendant, then it shall be set aside against all the defendants. Now, can the court do that? Only one defendant is appearing. He said, I am not aware of what is the issues with the other defendants. But kindly set aside the order against me. That, set aside the ex parte that has been passed against me. Can he say that? The answer is no. So the court will have to listen to the other parties as well, other defendants as well. And therefore, what will happen? The court in this particular scenario shall not set aside the order. This is proviso number one. What is the second proviso? The second proviso tells us that if the defendant comes and tells us, oh my God, Your Lordship, there was a gross irregularity in serving the notice, we did not, serving the summon, we did not receive the summon. But then that is one reason, that is one thing. But then the court is very well aware that this person is living in the family, in the same family, there's a family dispute happening, they're living in one compound, and they are aware of the fact that the case has been instituted against them. If the court is aware of the fact that the defendant is aware that a case is pending against him, still he did not appear, that the defendant was aware of the fact that he has to appear before the court on this particular date and time, but then he did not appear, in that particular scenario, the court shall not set aside the ex parte order once it has passed. So these are the two scenarios wherein the court will not pass not set aside the ex parte order that has been passed, right? Now, the last rule of this order is Rule 14. Now, what does Rule 14 has to tell us? No decree to be set aside without notice to the opposite party, right? So once ex parte decree has been passed in favor of the plaintiff against the defendant, so if the defendant now comes and asks the court to, to set aside the ex parte decree against him that has been passed. Now, since the plaintiff has not appeared, the court cannot go ahead and set aside the ex parte order. Both the parties have to be there. Only then, in the presence of both the parties or in the presence of their representative, their advocates, the court will be setting aside the ex parte order. So once the defendant comes to the court saying that, Your Lordship, kindly pass the ex parte order, kindly set aside the ex parte order, the court will immediately send a notice to the plaintiff that, the defendants have appeared before the court and they're asking to set aside the ex parte order. Now the plaintiff will appear on another day that will be fixed by the court. In that notice that is sent through the court, right? in that particular notice, the date and time, everything will be mentioned. The plaintiff will appear and the defendant will also appear on that particular date. And then, in presence of them, and then the arguments and everything will take place. The court will also look into the evidences and everything. And then, if the court is satisfied, the court will set aside the order and go on for a fresh hearing, or the subsequent procedures would take place, right? So that was it with order 9. Thank you so much. I had good time speaking to you all. I hope I was able to do justice. Hope I was able to make you understand CPC, Civil Procedure Code, which is said to be a complex subject. With the cartoons and all, I hope I try to make a little more easier in understanding. I see so many of claps, hearts, and thumbs up. Thank you so much. So that's all from my side. That's the end of my presentation. Anyone would want to ask anything?
Thank you so much, ma'am, for that wonderfully clear and engaging session. Your breakdown of the procedures and consequences under Order 9 CPC was incredibly helpful for everyone present, especially for students and young professionals trying to strengthen their foundational understanding of civil procedure. And let's now open the floor for a quick question and answer. If anyone of you have any questions, feel free to drop them in the chat box or you can directly ask now. Are there any questions from your side for ma'am? Anything?
Not that I would want to know who all were listening. How many of you were students? Could I please have thumbs up, students?
Hello, ma'am. Hello,
Hello? Yes,
ma'am. Can I place my questions?
of course.
Ma'am, my name is Tithi, and I have placed many questions over here. That as you told that after dismissal, they can file a fresh suit. I mean, what is the time boundary? Then means limitation. Is there any kind of limitation that within such and such dates they have to fresh file the file means suit again?
Okay.
And what will be the reason exact that will be accepted for the court? Uh, Condition of delay, any kind of. So I would like to know that, ma'am. And
Okay.
is it,
Yeah. Could you please come up with the question again?
ma'am, after dismissal
Mhm.
of any case that is civil case, so be for the respondent or for the petition plaintiff's fault, if he comes again to the court that for such and such reason he was not be appeared before the court. So, what is the time limitation? Within how many days he can appear for the free suit? That
Oh,
is the question first.
so you want to understand that if the case has been dismissed,
Yes, ma'am.
right? And then the defendant comes. The ex parte order has been passed in favor of the plaintiff, right?
Mm.
And the defendant comes in, and the defendant asks to set aside the ex parte order passed against him, right?
Yes.
You
Yes.
want to understand within what time frame should he be appearing before the court to say that your lordship kindly set aside the ex parte decree,
Yes, ma'am.
right? So it completely depends from case to case, right? So it can there's while a case so once the it has to be analyzed with the point of view that whether the summons were successfully served. If the summons were served, right, he was appeared that on this particular date, say for example 3rd of September was the date, he was aware of the fact that on 3rd of September there was to be a hearing, right? So on 3rd of September, he does not appear. So any subsequent day, and if on the 3rd of September, so what usually happens,
Mhm.
Tithi, right?
Yes, ma'am. Yes, ma'am.
So Tithi, what happens that on one day, if the defendant or the plaintiff is not appearing, the court does not straight away dismiss the court case or pass an ex parte decree. The court gives subsequent chances, right? And then there will be a representative. Any person having any suit, any issue will be representing his case through his representative, which is the advocate, right?
Yes.
So if he is not appearing, if the advocate is also not appearing, but then they are keeping track, right? Have you ever gone to district courts?
Yes. Yes.
Titi. Yes, so you must be aware that even if the advocate or the party has not appeared on that particular date, they do keep a track, right?
Yes, yes.
On any subsequent date that is falling, the party might appear and then tell the court that these were the reason why I could not appear, and due to my non-appearance, an ex parte order has been passed against me. Your Lordship, I request to kindly set aside. So it depends on the next hearing, the next date that is fixed for hearing. On that particular date, the party can come and appear and ask the court to set aside the ex parte decree so passed against them. All right?
Okay, I do understand. And what if the scenario is like the plaintiff has served the summon to the defendant's address, but the defendant was unable to receive that summon for XYZ reason. Suppose he was not, he was out of station, or he was not aware that the case has been filed against him for XYZ reason. So that in that scenario, defendant was unable to engage an advocate. Now the date was very next day when the summon was served. Suppose today has summon served, and tomorrow is the next date, and that day defendant was unable to engage any advocate in his favor. Now the court means now the plaintiff's advocate was highlighted that defendant willingly didn't take the summon, and court gives some ex parte order, then the defendant can protect him with any kind of explanation in future, or he lost his opportunity.
No, he will never lose his opportunity, right? So it happens most of the time. Either what can happen is that the defendant has shifted from the address that has been put in the summons by the plaintiff, right?
Okay.
The defendant is no more staying in that place, right? He has shifted to another place, another state. But then in that particular case, if the summons are being unserved, now the summons will come unserved if the defendant is not on the address that is mentioned in the summons, right?
Okay.
Now, if he has moved to another district, another state, say for example, now it will be the duty of the police officials to find out their address. If there are cases where interstates are also related, all right, there are cases where the plaintiff or the defendant, while they were staying in this particular area, now they have shifted to another state. That can also happen. In that particular scenario, it becomes the duty. The court instructs the police officials to ensure that summons have been served. So you will also be having cases where you've heard that the summons that the person, that the summons from, say for example, from Bihar to has gone to Mumbai, right? So that also happens in order to identify, find out, locate that particular person, and ensure that the summons has been served to them. That can happen. And what was your another question?
Ma'am, another question is that is someone was tried to serve but did the defendant. Now the second question: if the plaintiff willfully did not serve the summon and file a case, now defendant come to know from his relative or somebody that a case has been filed, and he checked from the cause list of the honorable court. Yes, there's a case. Now in that scenario, what should the defendant do? Defendant should appear without any summon before the honorable court and try to protect him or give any explanation that I didn't get any kind of summon, but the case has been filed against me. I can check it from the cause list. This is the case number, this is the CRN number, and this is the case dates, and this is the filed in the single bench or division bench before your lordship. So can he do that, or he cannot? He will stay silent. What should?
So he has two ways. First of all, he can just ignore the fact that a case has been instituted against him. People do it in order to delay the process. That I did not receive I did not receive the summon. He has not received the summon, like you said, right? So he can go. He can. Nobody can ask him anything because the summons have not been served to him. If the summons have been served, it is the duty of the plaintiff to show that the summons have been served, right? So if the summons have been not served, he can choose to lay back and not respond, right? And the other thing is, if he is a very good person and if he does not want to prolong or delay the process, he himself would appear even though the summons have not been served. We have seen in the previous rules, the defendant will appear before the court, and the defendants will say that this is the case against us. And even if the plaintiff is not appearing in that particular case, the defendant is appearing, and the defendant says that the plaintiff is alleging me for 10 rupees. I explained the previous rules. That's the plaintiff that the plaintiff has have accused me, that the plaintiff is saying that I owe 10 rupees to them. However, I do not owe 10 rupees to them. I owe only 5 rupees. So for that particular amount only, the defendants will be liable. They will pay their amount, and then the case comes to an end. So the plaintiff have both the discourse. They can either choose not to appear before the court, or they can actually choose to appear before the court and take their onus, take their responsibility.
Okay.
Okay, Tithi?
Thank you, ma'am, so much. Thank you.
You're welcome, Tithi. I hope it's almost time.
Ma'am, last but not the least, slide rule 3. I want to request you again to give me some explanation on rule 3, please, if possible.
Okay, Tithi, why not? Where neither party appears to the suit be dismissed. So it's very clear, Tithi. So what happens? I explained you in the beginning also. So
I understand. I understand. Actually, I missed the slide, ma'am. I missed the slide. Okay, thank you, ma'am.
you
I
see,
understand.
okay, all right. So any more question? I think we've almost crossed the time.
Excuse me, ma'am. Good evening.
Yes, Harshit. Good evening.
Ma'am, just need an. Can you just explain what an ex parte order means? Actually, you didn't get it completely. If you could
Okay.
explain.
So Harshit, what happens that when both the parties are appearing, both the parties will be heard, right? And then the evidences will be taken into consideration, and then the final argument is coming, and then the judgment comes, right? Right?
Okay, ma'am. Yes, ma'am.
So, and when we talk about an ex parte order, what is happening? The plaintiff appears, right? And the
Yes.
defendant is not appearing. In that particular case, the court is not hearing one side. Without hearing one side, ex parte, the court will make or pronounce a judgment. This judgment will be called ex parte. Why? Because you did not hear the other party. Ex parte order itself says that one party has not been heard. Where only one party is heard, and then you get a judgment in your favor, that is called an ex parte order. That order will be called an ex parte, and it will be specifically written an ex parte order.
Okay, ma'am. Thank you.
Okay, Harshit. Yes, so can we end the meeting?
Ma'am, this is a wonderful session, I want to say, and I will wait for any kind of session on criminal case scenario, if possible, in future.
Sure, Tithi, we'll see if the organizers are willing. We can have another session.
Thank you, ma'am. Thank you.
You're welcome, Tithi. All right, so should we exit the meeting?
Yes, ma'am, and as we come to the end of this insightful session, so I would like to extend a heartfelt thank you to you once again for being here with us. And honestly, ma'am, it was such a wonderful session, and you really cleared almost all of our doubts and queries regarding to CPC, considering the fact that it's a bit tricky. It's a bit tricky code in our law journey, and we truly appreciate your clarity, warmth, and depth of knowledge. We look forward to collaborating with you again in the future.
Sure.
And thank you so much, ma'am, once again.
Yes, thank you, Harshit. I just try to share my knowledge with you all. We are all in this process of learning every day, and it was really nice interacting with all of you all. I was happy to see so many people there, so it was a good time for me. So, all right, we'll exit the meeting. Thank you, everyone. I had a wonderful session as well. So, see you sometime soon.
Thank you so much, ma'am.
Yeah, okay. I'll exit the meeting.
Thank you, ma'am.
To all the attendees, just wait for a second. So, a big thank you to all of you also for being so engaged and interactive. I appreciate that. And your participation means the world to us. And it's just a quick reminder for all the participants that you will receive e-certificates for attending today's session. If you have not registered yet, so please check the registration link that was shared earlier with you all. And until next time, stay curious, keep learning, and follow the legal quorum for more such valuable events. And we have taken a note for all the participants who want to have another interactive session with ma'am. So have a great evening ahead, and please do remember to fill the feedback form. Thank you so much, everyone. Regarding the PDF or the PPT which ma'am had shared while giving the session, so we'll just collaborate with ma'am once again, and if it's possible, then we'll share with all of you. Thank you so much, everyone, for joining today's session. And once again, please fill the feedback form.